Hi, Brent Norling from Norling Law here. Thought I would cover off a fairly controversial topic around the morals and ethics of a restructuring situation, and particularly where they may not be aligned. So it's pretty common these days for companies to be restructured, one entity to be burned and a new entity to rise from its ashes and continue trading. The losers in that situation can often be some of the creditors. The construction industry, it's often the subcontractors that lose, and often we find ourselves acting for subcontractors, pursuing directors in that situation, particularly where directors have traded recklessly and contrary to their statutory obligations, and in those circumstances directors can be personally liable for the losses of the company. But also we help shareholders implement these kinds of restructures, and there's often very good reasons why these restructures are necessary. And so from an ethical perspective, there are very ethical ways to restructure a business, particularly around Phoenix companies. The starting point is that they are prohibited, but there are exceptions, and there are ways that directors of failed companies can trade on in a new company with a similar name. But often that's perceived to be morally wrong, and sometimes it is, but sometimes it's not. And I just wanted to talk about a recent case that we did where we assisted the shareholders to restructure their business. If we didn't restructure their business, they would have lost about $10 million in the entire company, and portfolio of retail stores would have closed, and many staff would have lost their jobs. Because we were able to restructure in the way we did, they saved $10 million, and also most of the staff's roles were preserved. So about 90% of staff got to continue on into the new entity structure, and the non-profitable locations were removed, and it was essentially some landlords and some rat and mice creditors that got burned in that process. Here you have two sides of this. On one side, if you were to look at it from the 10% of staff in those landlords, this might be seen to be morally wrong. These guys are out there, they're continuing to trade, and they've avoided paying these debts. That's one way to look at it. The other side is, if they didn't do this, everyone would have been unpaid and everyone would have lost their jobs, and arguably that would be a travesty. And so often ethically correct, and in some eyes morally wrong, and this contrast we see play out on a day-to-day basis. So there are options when it comes to insolvent companies that are beyond just a simple liquidation and close down of the business. There are ways to save the business even if you can't save the company, and so if there are shareholders out there that want to explore their alternatives, we're always happy to chat, get in touch. And conversely, if there are creditors of companies where this has happened, we're also happy to have a chat, because there are very strict rules around how these restructures can happen, and often we see it happen incorrectly, which can leave the directors personally exposed to the creditors. So if you've got any questions, happy to chat. Drop in the comments below, get in touch directly, and we'll be very happy to answer your queries. Thank you.